the judge concluded, and I will read it for you, the allegations of making false statements about the petitioner's nationality and the allegations of illegal practices, misconduct, or irregularities against the second, that was my client, and two fifth respondents, namely issuing illegal instructions prior to polling day, failing to allow access to national ID cards, failing to require an oath from voters objected to, and failure to record objections to voters on polling day, are struck for failing to constitute illegal practices under the Elections Act, or failing to constitute election irregularities or offenses during the conduct of the elections. In the body of the judgment, the judge points out that, in fact, the instruction given by the Supervisor of Elections to election officials to ensure that persons who appear at the polling station whose names were on the ballot, on the register, to ensure that they voted, the judge said that that instruction was in keeping with the law. And therefore, it could not have been an illegal practice for the Supervisor of Elections to do what the law required him to do. Now, my friends, that is a technicality. The judge ruled in the body of the judgment that Mr. Grant's complaint that he was not given the list with the photographs. The judge said it did not matter because the list he was given with the names was generated from the same database as the list with the photographs. So he had the same information without the photographs. And therefore, it didn't matter. But you see, that's the problem with people who can't lose, can't take defeat. It was not too long ago, you will recall, in another matter in which I was involved, with the matter against the Attorney General and the finding of the Attorney General in contempt. When the Court of Appeal ruled in favor of the Attorney General, you will recall what Mr. Grant's response was. It was to allege that somehow the Court of Appeal had engaged in some underhanded activity in somehow releasing the judgment to the lawyers beforehand. That's what this was. I said before, and I will say again, and I have pointed this out to you because I hope that you will take some time to read it to edify people. But I said from the beginning, when this petition was filed, to those of you who asked us, and to anybody near, I said, there was absolutely nothing in this petition. Absolutely nothing. I think that has been borne out by the decision of the court. Everything was thrown out. Everything thrown out substantively. Not any procedural thing here. This was not a technicality. And I think Mr. Grant ought to accept the defeat and not characterize the judge's work. A very detailed, I must say, a very detailed, comprehensive, and meticulous judgment. When you read the judgment, you will see the judge creates charts. She has charts in there to show what the law required and what Mr. Grant did, to show how bad the petition, badly I should say, the petition was drafted, and how wicked the allegations were. That's not the sign of a leader.
It's a very serious matter. To charge him with fraud is equally serious. And I stretch myself to say a lawyer ought never to put those kinds of charges on paper against any individual unless he has sure facts of great materiality upon which to found those wicked allegations. For the avoidance of doubt, I want to make it clear that Mr. Grant's petition has not and cannot go to trial. Before the petition can remain alive. The petition has to allege certain things which are capable of proof. So what we did as lawyers was to mount an attack against the petition in its form and content. It was a preemptive strike, demonstrating that his petition was vexatious, frivolous, and totally bad in law and misleading in fact. And the learned judge agreed. And that's an end to the matter. And he cannot appeal.
I just want, just for clarity, to point you to paragraphs 113 and 114 of the judgment. And for the listening public, let me read it. It had to do with what the judge had to say about Mr. Grant's allegations that my client, the Supervisor of Elections, had given instructions and was part of this plot to ensure his defeat. The judge says this at paragraph 113. Section 71 of the Elections Act was also amended. It appears that the presiding officer is now under a duty to request the voter to produce a national ID card before issuing a ballot paper. Suffice it to say, an instruction not to perform this duty would amount to an instruction to violate the provisions of the Act. Section 71 was further amended by Act Number 2 of 2008 to provide that a presiding officer may issue a ballot paper to a voter who is unable to produce the national ID card if the presiding officer was satisfied that the voter appears on the photo list in Form 3A and the voter presented some other form of government picture ID. The judge points to this section in the law in which it is provided. And therefore what the Supervisor of Elections said was what the law provided for. The judge goes on in paragraph 114 with regard to the ID cards. In a practical sense, the judge says, there is no difference between the national ID cards and the photo lists because both would have been generated from the same electronic database. And the judge goes on, but the purpose of the voter verification list would seem to be to verify the information when the voter presents his national ID card. The verification list cannot serve that purpose if the voters are not required to produce the ID card. However, she concludes, as insalubrious as it may have been for the second respondent, that is my client, the Supervisor of Elections, to issue an instruction to the officers to perform their duties in violation of the Act, if indeed he did, but for the purposes of these applications, I will assume that the allegations are true, it is difficult to see how this instruction would have led to persons voting who were not entitled to vote or prevented persons who were entitled to vote from voting. That's the judge's words, not mine, not the Supervisor of Elections. She goes on, the learned judge goes on, it has not been pleaded that the petitioner did not have a photo list, that the presiding officers allowed persons who were not on the list to vote, nor that the petitioner suspects that the persons who presented themselves for voting were not actually the persons on the list. And this is what the judge says. And perhaps it puts an end once and for all to the statements that are being made on political platforms elsewhere. The judge says this: once these persons were on the photo list, they were included in the register of voters and they were entitled to vote. Now, this judge is not the first one to say that, you know. Justice Bell, in the 2004 election petition, said the same thing. Yet Mr. Grant still filed a petition and still made the same allegations. I can't help but observe that there is one of our members of the press today who I noticed didn't file a petition. Maybe he listened to what the judge said in 2004. So that is all I have to say for now in defense of the Supervisor of Elections